So coming in on such short notice. Mr. Buckley.
Thank you, Your Honor. Good morning. My name is Matthew Buckley. I'm an assistant city solicitor with the city of Somerville. This case is about whether an arbitrator can appoint the city veteran services director over the mayor's appointment. Essentially, there is a statute, Chapter 115, Section 10, that conflicts with the collective bargaining agreement. The collective bargaining agreement contains a very general preference provision. It does not say anything in the collective bargaining agreement about the Veteran Services Director specifically. Essentially, there are two units of employees that are at stake here. They have separate collective bargaining agreements. There is Unit A and a Unit B. Unit A is they are very generally higher level, higher paid employees. They are not, as was described in Appellee's brief, department heads. I believe that there are one or two, including this position, that is a department head.
Is the reason that this position is covered by the collective bargaining agreement, I think you say it's just some historical artifact? I mean, there's nothing...
Well, we really don't know why. Essentially, it was included within the union sometime in the past. There's no evidence as to how or why that occurred. The particular provision at stake here, the thing I was trying to point out was that it was not, we're not trying to say that it is a provision that is illegal and constantly butts up against the statute. It's a very general provision that gives Unit B preference over non-union applicants for Unit A positions.
Are you saying that if the collective bargaining agreements had specifically said for this position that they would get priority over anybody that...
No, not at all. Those conflicts that I'm about to talk about would still exist. I'm just pointing out that we're not, the city's not saying that it is an illegal provision. Right. It is a provision. There are dozens of Unit A positions that Unit B applicants could apply for which there would be no statutory conflict, and it would be valid.
On that same point, the statute says that the mayor appoints the director and any assistant or deputy directors. Are there assistant and deputy directors?
No, there are not. There's just a director.
So that would be, I take it, in your view, the same problem if there were such individuals.
Right.
That were included
I mean, as the court knows, there are, if a collective bargaining agreement conflicts with the statute, and the statute is listed under Chapter 150E, Section 7D, then the collective bargaining agreement prevails.
Right.
In this case,
let me just ask you one other background question.
Go ahead.
There's no problem with this position being covered by the collective bargaining agreement for purposes of wages and time of work and things like that, is there?
No,
it's
not that
just
I'm
the
aware of.
appointment.
It's just the appointment.
It's the appointment that's at stake here, and that's the only thing that's really in conflict with the collective bargaining agreement, and why we think the statute should prevail over the collective bargaining agreement.
Okay.
Because the statute says nothing about the job. I mean, it just deals with the appointment by the mayor.
It deals with the appointment, and it specifically sets forward that the mayor shall appoint and the Board of Aldermen, or the local legislative body, shall approve.
When was the statute first enacted?
In 1946, it was first enacted, and there's very little case law on it.
That's before we had collective bargaining, of course.
It was.
And then has it been amended in the recent past?
Not for our purposes here, not that I'm aware of. I believe it may have
Now,
been.
it would be all right to bargain under the statute to get the candidates, wouldn't it? As long as from your position, as long as the mayor had the exclusive authority to make the final appointment.
Right, and that's very
there
similar
could be
to
discussions, and it could be someone from Unit A or Unit B or whatever it was, and then, but he may or she makes the last decision.
That's very similar to the line of cases that this court decided in 1976. It was the Danvers.
Right,
it was
the school cases.
In those cases, interestingly enough, those are about school teacher tenure. in one case, they had stayed, or two of those cases, they had stayed arbitration, and the court decided it was premature to stay arbitration because an arbitrator could decide certain rights that may have been based on procedural aspects, but that it could not, so long as it did not make the ultimate decision as to tenure. And the last case, the Bridgewater case, which I think is at 319, they actually ordered reinstatement. However, they did not order tenure. In this case, they made a permanent appointment.
Well, wait, but you are objecting to the process, aren't you?
Well, we're not objecting to the process. There is no process here.
Well,
This
you're
is very
objecting
similar.
I mean, if the process leads one candidate and you don't want that candidate, you're objecting to the process.
Well, it's my position that it's not really a process. This is very similar to the Berkshire Hills case, and that case was, I believe it's 375 Mass 522. In that case, you had a very similar provision in the collective bargaining agreement that gave preference to internal candidates over external candidates if and the language was extremely similar, if the qualifications were substantially equal. And in the appointment of or the hiring of a school principal, it butted up against the statute in which, and again, very similar language. It was a lengthy statute, but they focused on one sentence where it said that the school committee shall hire for every school a principal, essentially. And and the same thing was at stake. And what they said was that there wasn't really a process going on there. The issue isn't the process. The issue is the selection. There are things in the collective bargaining agreement about a process, such as you have to post the job. You have to conduct interviews. We did all that. There's no procedural. If the only thing they're saying is we didn't select the right person, there's no process that we didn't follow.
But I think, isn't part of your argument also if you use the City of Lynn, the appeals court decision of sort of breaking these decisions up into three groups,
Right.
you would say this is a specific and narrowly focused statute for which
right.
you don't need to sort of look to ancillary provisions.
Absolutely. I don't see how it could be more specific and more narrow. It says the mayor shall appoint a veteran services director.
So in that sense, it's different than the school teacher cases. Right.
Well, it is very much so, but not in Berkshire Hills is very similar if you want to apply the analysis of the process. And again, I agree with the court when you say that this is a specific and narrow, but to the extent that you're going to argue about the process, assuming arguendo that it is within that course of cases, I would say that even still, it is not. It should not be upheld.
That's about it. That's about it, isn't it?
Well, I would say that is pretty much it. It seems to the city, in reality, that when you look at a collective bargaining agreement that comes out with one person who ends up in a position because of the enforcement of a collective bargaining agreement, and it's a different person than the mayor appoints, it seems that it's downright axiomatic that they are in conflict. And I would just urge the court to overturn that arbitrator's award.
Thank you, Mr.
Thank you very much.
Buckley. Mr. Lamont?
Thank you, Your Honor. May it please the Court, I'm James Lamont, and I represent the association in this matter. I would like to start off by my remarks by, I guess, bringing into focus what I think it should not be in dispute here. The city does not concede that this contract term would be enforceable in the wide range of other job titles within Unit A. And that's an important concession because this is an employee.
The city doesn't concede or does concede?
The city does concede that.
Okay,
I'm sorry. They concede that. So we have an employee selection term Unit B, subordinate employees wanting promotional opportunities into Unit A, higher level positions. We have a contract term which, when applied correctly, reflects the parties' agreement. The arbitration award is nothing but the parties' agreement as to the outcome of that particular selection decision. It is in the category of cases that the court has not really had much chance to consider, and that is selection terms which actually dictate the outcome. Who's going to get the job? And it also points out why there are limits to our consideration of the school department line of cases in trying to make the analysis of whether it's okay for the parties to agree to that kind of an outcome. The school committee cases have a particular analytical method that look to the importance of local control over certain types of decisions and have a statutory source which is unique to school appointment cases. So when we look at school department cases and try to say, gee, does that provide us with a method of analyzing whether the city of Somerville and its association can agree to who gets this particular Unit A job, there are limits to that analysis. Having to do with the very factors, the tenure granting consequence of employment selection, the local control vested with school personnel as evidenced by the statutory sources. So there are strong limits as to why that doesn't provide the answer to
What
the
if
question.
you had a contract that said, the law, let's assume you had a statute that said the school committee appoints the principals of the schools, but you had a collective bargaining agreement that says, well, with the union, this teachers union, others, that we will, select a candidate after, bargaining, negotiation, all that kind of thing. And he or she will, in certain districts, and he or she will be the principal. How can that be good?
Your Honor, I did not get the last part of the question, that the selection is for which position?
A principal, and the statute says the school committee appoints all principals, shall appoint. And the collective bargaining agreement engages in some kind of process where one candidate for each of the principal openings comes forward. It can't be any good, can it?
Your Honor, if it's not going to be any good, it's because the statute vesting the decisional power in the school committee as to that particular topic, and it's going to be because of the public policy considerations that come into, that informed that statute. And that's...
Well, isn't this the exact same thing?
I mean,
it
could
is...
anything be clearer than this statute about who does the appointment?
Well, it certainly says what it says in terms of who shall appoint. The mayor shall appoint. And we've maintained in our, one of our lead positions is that that is not the type of decisional discretion that has informed some of the other appointment statutes, some of the other appointment decisions that we see in public sector cases. And that, again, evidences the limits of school committee cases.
Okay, when the legislature wrote 150E, Section 7, whatever, it didn't include this statute in its list of statutes
right,
that should give way.
That's right, Your Honor.
Well, don't we have to give that some thought?
What that does is helps the court to then frame the inquiry, because as we know, the non-inclusion of a statute in 7D does not mean the parties are not free to then enter into a contract that regulates it. It begs the question of whether the agreement they've come up with, the agreement to appoint, in this case, Paul Nelson to the position of Veteran Services Director, whether that is in material conflict with a pre-existing statute. And that triggers the analysis that the court has employed in the series of cases that we think is the most appropriate place to turn for how to analyze this. Does the contract, does the party's agreement to appoint Paul Nelson to this position, does that conflict with the statute in a material and direct way? Now, we've argued that it does not, that the power to appoint in the situation that this statute arises in can properly and most accurately be viewed as a mandate to the city, to the mayor, to have a position. One of the things that we would do in conducting the analysis of whether there's a material conflict between the parties' agreement and the statutory outcome is to look at the purposes of the statute, the language and the purposes of the statute. I've argued in our brief that...
Do you argue at all that because the mayor has only, under the collective bargaining, the mayor would only be appointing a union member who was equally qualified to the outside person, that means it hasn't been that there's no contradiction of the statutory power?
That
Make
is
that
part of
argument
the
at all?
argument, Your Honor. The parties have agreed, in this instance, as the arbitrator has interpreted their agreement, the parties have agreed that as between equally qualified candidate Paul Nelson and outside candidate Mr. Sinisi, that the contract, that the parties have agreed that Mr. Nelson would get the job. One of the things that matters in that analysis is that nothing about that decision contradicts any of the provisions of the statute as to who gets the job, whether it has to be a veteran. There's nothing in the statute itself that otherwise comes into conflict.
Except that the mayor gets to pick.
The mayor has to pick. The mayor has to appoint, Your Honor. The mayor has to appoint. And select, we submit, select and appoint are two doctrinally different things. There are statutes that this court has recently come into contact with in the context of the appointment, selection and appointment powers of the clerks of the court. The statute at issue in the case in 2004 said that the clerks have the power to select and appoint. There is a difference. The legislature has recognized a difference in the selection authority, the discretion, and in the appointing mandate, the appointing power. Now,
Did you notice, though, in the appeals court decision, it seems to me that the cases that are cited there are ones where the appointing authority agreed to follow a particular procedure, and here the city is being restricted in who it can appoint. So that's a little different, don't you think, from just following a certain process?
Your Honor, the procedures line of cases raise a question that certainly has to be confronted. In the school context, the court has made it plain that school committees can agree with their unions to follow certain procedures to yield the pool of candidates from which the person with the non-delegable decisional authority can then pick. And if those procedures haven't been followed, you will give effect to an arbitration award that sends that decision back to the process to yield the contractually mandated pool of candidates. That, we say, does not answer the question here. We submit that the process that the parties have agreed to can yield the actual winner of the contest. And the reason it can do so here, where it can't do so in the school...
But that's going a step further than the cases have gone.
No question about it, Your Honor. No question about it. We believe that the correct legal outcome in this case is that when it comes to filling the position in question here and all the other Unit A departmental head positions within the city of Somerville, that these parties can agree at the outset as to what the outcome is going to be, and that it doesn't step on the decisional, non-delegable authority of anyone else. Everybody in Somerville has to be appointed by someone.
Mr. Lamond, I understand that, but first of all, the appeals court keeps talking about the bare authority to appoint. The bare, what is the non-bare authority to appoint?
A non-bare authority, Your Honor, might look something like the mayor shall have the sole and exclusive authority to select and appoint the person.
But that, I mean, you're just reading into. You're assuming that that appointing authority. Let me back up. If a selection process yields only one candidate, what is left for the mayor to do? Sign a piece of paper?
To implement that, yes.
Why would you need a statute that says the mayor shall appoint this particular... I mean,
Your
in
Honor,
other
I
words,
understand.
somebody has to appoint. I don't know who appoints every employee.
We needed a statute in 1946 because the statute that existed prior to that, enacted in around 1945, made it voluntary for cities and towns to have veteran services directors' positions. The evil that the legislature sought to correct in enacting the statute that is in front of you now made mandatory that cities and towns have this position. So in terms of the purpose of shall appoint, there is a historical explanation for why the legislature changed.
But what about the requirement that there be an approval of the city council? Isn't that rendering, wouldn't your position render that provision superfluous? Because what do you need an approval by the council for if the mayor has to appoint the person who came out of the collective bargaining process?
Your
and
Honor,
it's ridiculous.
if anything, the inclusion of another entity in the decisional process evidences the non-exclusiveness of the decisional authority.
There's no decisional process for the city council to play. The mayor, it has no part. The mayor has to appoint the person that the process has culminated in.
Your Honor, I believe in the context in which this statute came into play, there was a recognition that the legislative body was the funding entity for all of the positions that the city employs. Why the legislature tagged on the selectmen, the city council as having an approval role, that's not evident from the statute itself.
But I can suggest at least one explanation, which is that the statute contemplates that the mayor will, in your language, select and appoint, but that very broad power was limited by you have to go to the city council, because in fact it wasn't a rubber stamp going through some other selection process. As it were, the mayor is selecting and appointing, but his authority or her authority is constrained by also having to have the approval of the city council.
Your Honors, I certainly recognize the uphill battle that we face here, but I would submit this, that there are any number of statutes, and we've cited some of them in our brief, where the legislature has empowered a public manager to appoint, shall appoint. One of the first questions here is how did this position get into the bargaining unit? I anticipated that question. If we look at recent cases of the Labor Relations Commission decision, the position of Veterans Services Director, the very position involved here, is found in bargaining units throughout the Commonwealth. As recently as 2005, the Labor Relations Commission created a bargaining unit that included this position. So make no mistake that the decision as to whether or not a collective bargaining selection term can be enforceable as to this job title is going to have ramifications.
Well, maybe your uphill battle isn't that bad. I mean, you convinced 25 judges of the appeals court because they all read
And the
signed
arbitrator.
opinions.
Your Honor, thank you, Your Honor. I
Court.
believe that if we conduct the material conflict analysis, there is a path to understand how the 1946 legislature could have directed mayors of cities and towns to have this position, and how the 1973 legislature could have seen it within the scope of collective bargaining to enact a procedure that actually selects who gets into that position.
Mr. Lamond, I don't know the answer to this question. Is the city council party to the collective bargaining agreement?
The collective bargaining agreement is between the city and the
Right.
union.
Right.
The mayor negotiates the collective bargaining agreement. The city council has to fund the collective bargaining agreement. We cite a case in our brief which this court had to occasion to address the interplay between those
Right.
entities. It raises the other point that this mayoral appointment power is a power, even if it is a selection power, even if I'm wrong on that point, even if it's some amount of discretion, it is a power that can be subsumed by the supervening authority of the city under Chapter 150E to enter into collective bargaining agreements that regulate topics such as this. In other words, even granting that in 1946 the legislature gave decisional power, selection power there, the 1973 legislature thought it was okay to allow the city, who employs the mayor, who delegates it to him to negotiate contracts on its behalf, to have that, to cede some of that decisional power to the selection process that it was willing to agree to with its union in order to provide the important promotional opportunities that contract terms of this sort bestow upon public employees.
I take it one of the criteria is all things being equal.
Yeah, no question
Now,
about it.
who
Your Honor.
makes the determination that all things are equal?
The arbitrator has said that what the parties meant by that is that if a good faith determination by the, in this case, it was the city personnel director. In this case, the person vetting the candidates, processing the analysis is set forth in the arbitration award in the appendix to in the case. If a good faith decision process assessment is made, then and the junior or the, in this case, the out of unit candidate is selected, if a challenge is mounted to that, then there is an evidentiary issue. Then there is a proof issue, borrowing or taking from the line of arbitral cases that give a meaning to
But
these
can't
sorts of
the
contract terms.
mayor say, look, I have a face I'm putting on my administration, and this is one of those faces that or one of those people that goes into the making of that face, and that the particular person that I'm selecting who's not in the union has certain qualities that they're going to go out into the community and do kinds of things that this other person is not going to do.
Your Honor,
does that do it? Does that cut it?
It doesn't do it because it is a topic that the city, the mayor's ultimate employer, the city could have previously agreed upon to a different outcome. What if it were the athletic department of the city and they had a similar face? There's no statute that says anything about appointing. If the contractual contract process, as the city concedes, could have dictated the winner of that contest, then the same thing should follow in this instance, because, as we maintain,
Yes, but
Section
that-
10 does not dictate the answer to the question.
Well, I mean, that's begging
where
the
we
question, right?
Mr.
I mean-
Lamond, I have one quick question. The 12% on all amounts owed if you were prevail, where does the 12% come from?
Your Honor, I believe we asked the court to apply the statute regulating contract losses.
Contract interest.
Yes, Your Honor.
Statutory content?
Yes, Your Honor.
Okay, thank you, Mr.
Thank you very
Lamond.
much.